My never say ma PENDREAM TV. PENDREAM TV there. Osia dem yopo.
Now let's turn to the trial in absentia. What does that mean? And under what circumstances does that even arise?
Well, I was listening to one of your guests, or I don't know whether it's
yes, my colleague Lavon. Yeah.
Okay, and he was making the point clear. I thought that you would have allowed him to conclude, and I will only say I have nothing useful to add. Okay. He referred to Article 19.3. To be honest, there is no express provision in our statutes or procedural rules or the Constitution, for that matter, spelling out very expressly and in clear terms how trials in absentia should be conducted. And so we should examine that on case-by-case basis. In the Sedina case, I think, if I recall, she was within the jurisdiction when the trial commenced, and I believe appeared in court at the preliminary stages and was even on bail before she traveled health grounds, and since then never returned. So the trial continued. In this particular instance, I don't know whether at the time Ofori and probably some of his other accomplices left the jurisdiction, they had actually been charged and did appear before any court, whereby his plea or their plea had been taken.
No.
I don't know.
No. Factually, nothing of such happened.
Okay.
Yeah.
So, in this case, the article that your colleague referred to will serve as the basis for any discussion. Whereas the entire Article 19, which comes under Chapter 5 of the Constitution, where we have all our fundamental human rights and freedom guaranteed, fair trial rules have been very clearly spelled out under Article 19, and one of which is the requirement that a person charged or accused of any criminal act should be tried in the presence of the person. But then there is that proviso that unless the person decides otherwise, having been notified. Okay. In this case, yes, trial in absentia is recognized if the accused person decides to waive that right to be present after he or she has been notified or had notice of the indictment. In this case, we then have to look at the methods by which the notice of the commencement of any criminal proceedings could be brought to this accused person or the suspect for that matter. Now, ordinarily, he would have been invited by the law enforcement, police, CID, Yoko, OSB, and so on and so forth. He would have been invited upon a complaint of some wrongdoing by a complainant. In this case, the victim is the Republic, all of us. And the complaint will then trigger investigation or an inquiry to the said complaint, where evidence is gathered, a docket is open, and possible charges referred in. And then he would have been notified of a court date simply by just being informed that you are to appear in court today or at this time, and so on and so forth, on these charges. I don't think that has been done, or could be done at the when he is not within the jurisdiction. So when this is not possible, what's next? Criminal summons can be issued. And if you look at the procedures provided under our criminal procedure code, that's the apprentice, it set out in clear terms how proceedings in criminal offense have to be brought to the notice of the person accused. Personal service is required first. That is the norm. That the person must be served personally by delivering a copy to him or her. When personal service is impossible, then you go to the next question. The law requires that a copy of the summons is delivered at the person's last known place of abode or workplace. And this to be given to any adult person 18 years and above, to be given to the person under investigation or the accused person. When that also is not possible, there are other means whereby the summons could be posted or affixed to any conspicuous place of the last known place of abode or the workplace for the attention of the person. And these are some of the things. So, Kemukuriaka is a well-known figure. At least his last known place of abode is there. His workplaces, his companies, and others are there. But the state is aware that he is not within the jurisdiction. But I don't see any exception in terms of criminal procedure that prevents the state from having this most of service utilized in the circumstances. Unlike several cases where once the plaintiff knows that the defendant is not within the jurisdiction, such most of service, including substituted service, is not allowed. But that there must be a specific order or leave to serve out of the jurisdiction. We don't have any such equivalent provision in the criminal procedure rules, whereby leave has to be sought from a court to serve criminal summons outside the jurisdiction. Remember that no country has extraterritorial jurisdiction over fugitives that are hiding in other jurisdictions. Therefore, the suggestion is that once the charges have been properly laid and filed before a court of competent jurisdiction, these charges must be brought to the notice of Kemukuriaka by all the means available. And by issuing criminal summons duly set on him at his various places of work or home, he will be deemed to have been properly sent or notified. And the choice will be for him to take advantage of the fair trial, to be present and be informed of all his rights guaranteed by constitution and law, to face his accusers and to defend himself. If he chooses to waive these rights, I believe that once the notice requirement has been satisfied, the state or the prosecution can proceed.
I see. Okay, because I was coming to ask you about whether it is possible that they can work with U.S. authorities to serve him at his residence in the U.S. But you're saying no such powers exist?
No, I haven't seen any procedure by which summons or criminal summons be served through the foreign authority, unlike in several cases. However, there are other provisions under the Yoko Act and the OSC Act. They call it mutual assistance. I don't know whether it can avail them any such help to explore this mutual assistance to set a criminal summons out of the jurisdiction. Otherwise, summons are not the only means by which a person accused of a criminal act is notified or brought before court to seek justice. Warrants are also a different level. When summons, for instance, fail, warrants are issued commonly. So, a warrant may be may be issued, at the request of the prosecution by the court. Once a warrant is issued, an arrest warrant, there are international arrest warrants. Okay.
Mm-hmm.
So once the international arrest warrant is issued, then the government of Ghana, through the Attorney General, will be making a request from the jurisdiction where Mr. Koreata suspected or known to have been hiding for his arrest and possible return to Ghana. Then we come back again to the issue of what we call extradition.
Mm. So the number one hurdle that you face when you're dealing with trial in absentia, because listening to you, is service on the person, making sure that the person is notified of
the initial what do you call it charges.
Mm.
He must know, and how to bring this to his attention is the hurdle to be crossed. It isn't so much about the procedure, the trial process itself. Okay?
Mm-hmm.
It has more to do with bringing to his notice the charges made.
I see. So in this case, is it for you to because all these processes go through the courts? At what point in time would perhaps the court be convinced that you've made adequate attempts, or the court would have come to the conclusion that either you have attempted to or you have done everything you can to serve him?
It is so obvious that personal service is not possible. But the other means are there. Without exception, when a copy of any summons are delivered to any adult, inmate, or occupier of the premises that the Ofori and others are deemed to reside or at their workplaces that are indisputably theirs, of course, that will be deemed to be sufficient notice. Okay? If after all this notices, it still fails to avail himself, and the state feels so strongly that there will be the need to bring him personally to court, then the warrant may be considered. But that itself will have to face the challenge of having to go through the U.S. authorities and then coming back to the same point of
extradition
and all that. But at least at that stage, there's evidence before the U.S. authorities that he is facing some well-laid and clearly stated criminal charges.
Mm.
And that attempts were made to reach him and to bring this to his notice to be present, and that he will simply not take advantage of that. Then the compelling powers of the state or the coercive powers are triggered through the issuance of the warrant of arrest.
Okay. So if they get to the stage of this where they think that we need a warrant to be issued, can the case continue whilst that warrant is operational?
Well, of course, he has waived his right, but the only challenge I face, I stand to be corrected, is will he be deemed to have pleaded not guilty? In the case of Ferdinand, at least he was in court.
Yes.
When his plea
Was taken.
Okay. She did not plead guilty. That was why there was a hearing or a trial. So how is the state going to take the absence of Mr. Furiata to mean that he is deemed to have pleaded not guilty and therefore there should be a full trial? Or he will be deemed to have pleaded guilty and therefore he must be convicted on his plea and sentenced as such in absentia. These are very technical procedural issues for the prosecution, the Attorney General's Department. On that open.
So from service, you have the issue of a plea.
Yes.
So all that will be argued before the court. The court has to be satisfied before the case can proceed. Once the court is not satisfied, it means that it must wait until the man appears to plea.
Yes, because in ordinary criminal cases that some of us have defended, after all the pre-trial procedures, out of court procedures, normally at the police station, you go and so on and so forth. When a lawyer is involved and the prosecutors are charitable or the investigators, they call and inform you that the matter is coming up for hearing today in this court and at this time. Very informal. Or the accused person is informed that we are in court tomorrow at this time in this court. And then by that time the person may have been on some problem for a review. And therefore you come voluntarily to court, whereby once a charge sheet has been duly laid and filed, the first thing to do is, unless the prosecution is not ready to start, the plea is taken. And then probably a repeat bail application is made and the person is admitted to bail or is remanded to reappear or is remanded while the plea is deferred. It is when the person fails to voluntarily show up that the next stage is triggered. That is to say, a warrant, a summons, formal criminal summons are issued, or a warrant of arrest at the highest level. In this particular case, much of these that I have talked about are simply not available. The options are not available.
I see. So very interesting waters that we are swimming in. But in this case too, I realize that the Office of Special Prosecutor has been communicating with a law firm that claims to be representing Mr. Ken Ofori. Does that make anything easier?
Yes. In criminal procedure, the rules are not as strict and technical compared to the civil cases. Okay. Remember that there were earlier invitations. OFC, they have been in touch with these lawyers because on previous occasions, these lawyers appeared as his lawyers to represent him in some pre-trial and pre-trial out of court proceedings having to do with the matters that are leading up to the charges being preferred. So these lawyers have established a relationship with the West. They have held themselves out as having Mr. Ofori as a full authority, so to represent. So they have been communicating to them. Copies of the tax and whatever have been shared with them for the attention of their client. So it will be in their own place and the client is there to adhere to those rules for his plea to be taken, and thereafter he chooses to act. He will be essential. Even if he still doesn't to voluntary upon all the no cases or brought to his attention, of course, it may become necessary to issue that warrant of arrest, and Ghana may have to depend on the processes allowed by the U.S. authorities to have him arrested and extradited to Ghana. If that also doesn't work, what next? Will he be deemed to have waived his right to have his plea taken? And if so, what plea will be entered for him? Will it be one of outright admission of guilt, for which there will be no need to take any evidence by his convicted and sentenced on his own plea in absentia? Or he will be deemed to have pleaded not guilty, for which reason full-blown trial is commenced. These are some of the issues that may be of concern to the Republic and the Attorney General.
I guess you will also be watching this closely to learn how this proceeds. But in all your readings, I know you do the Ghana Law Report, where they deal with precedents from as far back as the 80s. So you also read from across the world, among others. Have you come across anything of such, especially within our jurisdiction? Is there precedents that can be followed?
Not at all. I haven't. I'm yet to.
None?
But I almost there could be something. I have not conducted any research on it. In fact, within our law, especially this same Article 19 and then the provisions of the Criminal Procedure Act 30, the only time that a plea is presumed to be one and nothing else is those capital offenses that carry the death sentence. I'm told even death sentence provisions are amended. In those cases where a person expressly pleads guilty, a non-guilty plea is entered, because by all means the state is required to give some evidence. Okay. But I haven't come across a situation where a failure to take an accused person's plea because he or she will not avail himself that purpose. That absence is deemed to be an automatic plea of guilt or a no guilty plea. We can still find out something on this, and I think there are more knowledgeable people when it comes to criminal prosecution and defense. We can still find out. I must be honest, I'm yet to do any serious research on it.
Okay. Now, let me conclude by asking you a question, because all this started with the special prosecutor saying we need him to answer some questions. I know you perhaps you have represented clients who perhaps initially the authorities thought were guilty of something, but after appearing before those authorities during the investigative process to answer some questions, they were convinced that the guy had no question to answer. In this case, is the hand of the Office of Special Prosecutor being forced? Because perhaps if Mr. Ofori has appeared to answer those questions, he may not have even been on the charge sheet at all. Is his hands being forced?
Somehow, yes. You are right. You know, the procedures adopted by the law enforcement, the investigative body, are not devoid of the usual due process requirements or fair trial. We're talking about fair trial when the matter is in court, but before the matter goes to court, there is also due process. And so due process doesn't only occur when trial begins. And therefore, it is fair for the law enforcement to whom a complaint has been made, although it's a state agency, and the complainant being the state or the republic, the law enforcement, the investigative body, still deems it necessary to hear the suspect. At that stage, the person is only a suspect. To clarify matters, but remember, no suspect is under any obligation to afford the investigative body the opportunity to build a case or to arm the investigative body with information or evidence to prosecute it. Because remember, there is also the right to remain silent. So even if Mr. Ofori had appeared before them, he will be reminded of his rights, all the several constitutional rights, including the right to remain silent. He could choose not to talk and say, look, my silence is my response, and I stand by it. I reserve my comments or my statement for court. I don't intend to talk to you. That will be it. But then, his silence may not help in certain circumstances because, after all, some of the matters could have been clarified and the state would be so satisfied that this is not what we thought, and will not even warrant a further step. It ends there. Rather than keeping mute, only to be charged with, let's say, frivolous offenses, but you are taken through the trial process for years. Your liberties are curtailed because each time the case is called, you must be there. So it doesn't help someone who has a genuine and solid defense or explanation to fail not to speak on all occasions. It is only when the state is trying to engage in an act of inquisition, trying to extract evidence from a suspect by unfair means in order to build their case, that a suspect will exercise that right to remain silent.
This is what the case tracker says. Now, the 7th May 2026, that was last updated, is about service and extradition processes ongoing. That's the current status. And apparently, the Ken Ofori has 28 counts. NS Dako Ofori has 12 counts, all corruption-related offenses. And he said the extradition process is active. And this is what he says. The last time they were in court, at the hearing on 23rd April 2026, the prosecution informed the court that since the last adjournment, related proceedings have taken place in General Jurisdiction Court 10 in the Supreme Court concerning the prosecutorial powers of the Office of the Special Prosecutor. The prosecution invited the court to take judicial notice of these proceedings. The prosecution further indicated that in light of the current circumstance, the OSP has filed a notice of appeal and an application for stay of execution with a return date set for 21 May 2026. Accordingly, the prosecution requested an adjournment pending the determination of the application for stay. Counsel for all accused persons present, except Kenneth Nanaya Ofori Atta and his Chief of Staff, Ernest Akori, who remain fugitives subject to extradition requests and summons processes in the United States, did not oppose the request but urged the court to set a sufficiently distant date to avoid repeated adjournments. This is the ruling of the court. The court, noting the decision of the General Jurisdiction 10 court and the subsequent filings by the OSP, granted a request for adjournment. The matter has been adjourned to 26th May. but he didn't provide an update on what happened on 26th May. A date set after the return date for the application for stay of execution. And they also talk about what happened on 26th March, and before that, 26th February. So there's currently ongoing a case in court. I think the biggest challenge they have is serving these two people, Ken Ofori Atta and his chief of staff, Ernest Dako Akori. How the two of them ended up out of this country alone is suspicious enough. Yes, it's suspicious enough for you to make certain suggestions. Because how will his chief of staff not even be in the country to answer questions? And you see, the interesting thing about this case, and we'll speak to Lawyer David Ametepe and Lawyer Andrew Appiah Dakwa shortly, about if I decide to try somebody in absentia, what do you do? What steps are taken? Is it something that has been done over and over again, or is something new to our jurisdiction? And Adam, okay, so I think something happened in the matter of Jakpa.
Yeah.
So that was when Godfrey Adami was Attorney General, filed a case against Jakpa and Atta Forsen. Now, when the tape came out, I think the lawyers for Jakpa then filed something. Is it something that I've forgotten what they filed, but essentially they were trying to say that based on the evidence in the case should be struck out.
Okay.
Now, when it came before the court was of the opinion that this is novel. This has never been done in our courts before.
Yeah.
That this applies in the US, not with us. That in our jurisdiction, this is not in our books. So we cannot, the court says, we cannot grant you what you are asking for because it is alien to the way we operate.
Yeah.
Okay. So there are many things that maybe it is on the books, but in most cases it rarely happens where people are tried in absentia like that. Many a times the person has to enter a plea. You have to try to serve the person before you fail or anything. Then you have to find a way and you have to try to serve them through other processes. Maybe post it on Facebook, post it where you know they live and everything. In this case now, we can now work with the U.S. authorities to serve Ken Ofori Atta because it's now provided a place of abode to the U.S. authority in getting the permit to stay in the U.S. Yeah. So now we can serve him.
Yeah.
We can serve him. So the interesting thing is whatness. How will the rest proceed? You see? Yeah. And there are many questions in your mind because, Charlie, the fact that I say Nancy has done something doesn't mean that if Nancy appears before me, because if I'm sitting before you and you are making an accusation against me and I am given the opportunity to defend myself, who says you not come to the conclusion that on this matter, there's not enough, strong enough evidence to say Lavo should go inside?
Yeah.
You see, and that's the interesting thing about it. What we needed Ken Ofori Atta to do, from what the Office of Special Prosecutor said, was to answer questions.
Exactly.
So how did we get it?
I think the OSP has got a lot of things wrong. But to the question whether Ken can be tried in absentia, yes, he can. And our constitution has made provision for that. But there are a number of things one must do to be able to try someone in absentia.
Okay.
If you read Article 19.3 of the 1992 Constitution, it clearly states that a criminal trial must take place in the accused person's presence unless the accused person refuses to appear after being duly notified of the trial.
Being duly notified.
Duly notified. In this case, the OSP has not been able to serve Ken.
Yes.
Debbie Kama, I'm not PENDREAM TV. Now, so far so good. Say open online portal e wo Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.